this meeting to order. There is a quorum present and absolute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, 2.0, additions, revisions to the agenda. Anything? 3.0, correspondence, public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair, give your name and address, and limit comments to 3 minutes. Any public comments? Okay. Under correspondence, we have a couple of letters that I wanted to note. I'm not going to read them out loud this time because they're pretty lengthy. The first is from Sheriff Betancourt in his capacity as the Fire Services Board Director. Basically asking us to consider making the Fire Services Coordinator, who's been Shannon Popick, but she's retiring shortly, to make them a county employee. So, and he just cites that the benefits package, things that we can provide, are perhaps more extensive than what the Fire Services Board can do, and makes it more competitive. So, I imagine this is something Gary will raise again with us during budget cycle. So, just wanted to flag that. The second one is from Shannon Popick, Gilliam County Fire Services Coordinator. And it's basically just providing feedback on the work sessions that we're holding concerning our county grant programs. Basically saying that she's grateful for what the support that the court has offered previously, but that one of the things that she's noticed is that our grant process in particular is one of the easiest, and that she would be supportive and understanding we would have a more stringent process. So she also raised, which I thought was interesting, kind of how the timing affects taxing districts when they're preparing for their own budgets. So that's just something we may want to be mindful of as we're working through those sessions. That is all I have for correspondence. 4.0 is consent agenda.
I move we approve the consent agenda.
A second. It's been moved and seconded that we approve the consent agenda, which consists of 4.1, consider approval of bills pending review. 4.2, consider approval of January 23rd meeting minutes. Consider appointments to CAPECO board. Sherrie Wilkins is the primary and Mike Weimar is the alternate. And set fiscal year 2019-2020 budget calendar. Is there further discussion?
Yeah.
Not all those in favor?
Aye.
Any opposed? Motion carries. Okay, all ready to unfinished business 5.1, printer talent update. So we have met, I think, one time. Printer talent has since the last, our last meeting. And Sherrie was there as well, so she might want to chip in a little bit if she thinks I missed something. But the gist of it, or the update, is that the Sherman County loan has been approved. It was accepted by the Frontier Telenet Board for $100,000. It's a zero interest loan. The term was about 6 months. And so anyway, that's been accepted. Wheeler County approved a loan or offered sort of a loan of $100,000. It was a 2.5% interest rate to be paid back over a period of 4 years. That agreement was tabled. And Wheeler County Court, I believe today, was actually looking at the loan documents, because the loan documents themselves had not been approved. So my understanding was they were taking those up today. And so I am anticipating that will come back before the Frontier Telenet Board. The concern that I continue to raise, and that I will continue to raise even after it comes back to us, is that it does not appear to me that Frontier Telenet has a plan to be able to repay those loans. And in Wheeler County's particular instance, Sherman County has sort of accepted, I think, the idea that their loan might have to turn into a grant. That may just be the nature of it. Wheeler County, the fund that they're borrowing the money from, really needs to be repaid. And so I have concerns that we will not be able to do that realistically, and that we should not be putting one of our members of Frontier Telenet in the situation where we're asking them to take money out of an account with assurances that they'll be repaid, that we can't. So that was a little bit, I think, contentious about whether to accept it or not. And so we'll kind of see what happens when it comes back, if Wheeler County makes any modifications or reconsiders how they're going to loan the money, or if they're going to loan the money. So that's kind of a TBD. I did let them know that we were rethinking how we would support Frontier Telenet, that we still want to be a partner, but that we felt that perhaps our support would be best toward targeted things that would move Frontier Telenet towards more sustainability. So they need a second auditor, they need for the turnaround consultant, there's specific things that come up that are a direct thing that the towers that service Gilliam County need, and Gary's saying to us, we really need a generator here, something that would probably be things that we would be more likely to fund than just general operating kinds of things. So they didn't really respond back as far as what next steps would be, and it does not appear that we're, I think, moving at a pace on the turnaround consultant that would require us to take action in this meeting or even next meeting. I think it may take a longer process to figure out what we're doing. I did also say that we were willing to take the finances in-house. As you can imagine, that was a uncomfortable conversation with Jeannie at the table. There were quite a few members of the public there, and every single one of them that spoke was supportive of the idea of one of the counties taking the finances in-house. And so I am going to continue to raise that as something I think we need to do to get solid numbers so that we are making good decisions about what comes next. So that's kind of the update. The only other thing I think is just worth flagging, it does not come before the board, the Frontier Telenet board officially, but we did get the audit back. And so I think this kind of speaks to, I mean, it's a public document, it's on the Secretary of State's website, so I feel like I can share it here. But one of the things that really concerned me is if you look over the history of the auditing of Frontier Telenet, for the most part, the audits have looked fine coming back. This year, they in essence said that they did not think Frontier Telenet would survive another year. So that's just something to flag for people who are watching it, for us as people who are looking at potentially supporting it, that the auditors are saying the current funding structure is obviously not sustainable. I don't think that's news to us, but I think it's worth flagging for the public as well, that the auditors are seeing that is an issue, that we should anticipate that there will probably need to be emergency funding to sustain it. So I just want to be transparent about that. That was coming. So that is all that I have on Frontier Telenet.
I wasn't able to stay for the entire meeting, but I had heard that Jeannie had resigned her position, which would also put our offer that's on the table more, I don't know if it'll give it more weight or what the other members are thinking.
Yeah, so the end of the meeting, Jeannie did say that she was resigning. I have sought clarification, did she, because we didn't actually take action to accept her resignation at the time. It was literally when was adjourning it, basically, and said one last thing, and then added that Jeannie had said she was gonna resign. So we didn't really officially accept the resignation. And so it is not clear to me if Jeannie intends to stick with that, or if there's been further discussion that she has reconsidered that. I don't know. I do know, I have at least heard that, that Brenda Snow may be helping her a little bit on some of the finances. So I don't have that necessarily confirmed from Judge Morley, but that is what they're doing. But I have heard that that has been occurring recently since our request. So, so I imagine this will all come up again. It's not clear to me what Jeannie's status is, since we didn't actually formally accept her resignation. But
When is the next meeting?
it is I think it's the last Tuesday of the month. So it is the right now it's scheduled the 26th at 10 a.m. at Sherman County, the courthouse.
Okay, thanks.
Anything else? No questions? It's super fun.
Sounds like it.
I'm planning on just leaving it as unfinished business so sometimes I may not have an update, but just as a marker so that I'm remembering to provide updates so the two of you are informed about what's happening. So, so with that, let's move on. 5.2, consider formation of a county road committee, resolution 2019-01. Ruben, you want to take this?
Sure. So there's a draft of the resolution in the packet. After submitting that draft, I did have a chance to speak to Mr. Kennedy, the roadmaster, regarding some language in there that references the Public Works Department, and that was a holdover from some provisions that were in a similar Morrow County Road Committee bylaws. So I'm going to pass out here a red line of some changes that I made that just scratch out the Public Works and substitute in Road Department. And so there's the changes there in section 2 and section 7.
And that's the only change.
That's the only change from the packet. I'm going to provide Sandy with a clean copy so that we can sign it today. What I would like the court to take out, though, is the matter of dividing the zones. There was some talk about doing 2 from the north, 2 from the south, 1 at large. There was some talk about doing several different things. Sandy, I've got to hand it to him. He came up with a exhibit that would divide the county into 4 zones. Based basically what it is he took 19 and cut the county that way, and 206 he cut the county the other way to create 4 zones. And I'll be the first to admit it's not perfect, but it's tough. It's tough to really say what is north and south. What's going to happen when we have someone in Olex and there's an opening in the north section, so they fill it, but then there's an opening in the south section the next year, and someone that's very qualified from Olex wants to be on it as well. So it's really up to you if you want us to go back to the drawing board on this. It creates an additional issue in that theoretically you could have one person from for each zone that comes just from common. And a person in each zone, both in Arlington, with zone 1 and zone 2. So it's not without its quirks. I tried to address those the best that I could in the language of the membership and saying that it's acknowledged that the city of Condon and the city of Arlington are located in 2 or more zones. And this is section 2, about 2 lines in. Therefore, the county court shall consider an applicant's overall interest in the county road system as a primary factor in determining the selection of members. So, what am I saying is that you have discretion. If you have 2 people from zone 4, one's in the city, one's outside the city, you can take into account that the person outside the city has a bit more of an interest in the county road system as opposed to the city road. So it gives you that discretion. It also gives you discretion in that if you're unable to fill the committee membership with 1 person from each zone, that you can say, look, we have this qualified applicant from another zone, let's let them take the position. So it's going to be tough in trying to analyze all the Fs as we implement this. This gives you the discretion to make the decision based on what's best for the county road system, in your opinion. And then there is an at-large position for just anyone around. And obviously, people from the cities are completely welcome. It's just you have discretion to look at the county road system as a whole to determine who makes up the committee. I don't anticipate that you're going to have people knocking on doors to be on this.
If they're not on the county roads, normally they probably don't have that much of an interest in the county roads.
Exactly. And so this just allows you to take all that into consideration. That would be that. It's 4 positions. I've staggered the terms of office so that you won't have all of them coming up at once.
I thought, was it 4?
Oh, no, 5.
There's 5.
Excuse me,
Yeah.
yes. So they're staggered, and they are, that is in section 3.
And they'll just choose, did I read this right, that they're going to choose when their initial term is up?
By law.
By law.
So, yes, they can just determine how they want to do it, whether it's roll the dice or whatnot. And yes, 2 will serve until 2021, 2 will serve until 2020, and, or no, 2 will serve until 2022, 2 will serve until 2021, and 1 will serve until 2020.
Any questions? How do you feel about it, Dewey?
I think it's good.
Feel good?
Yes.
I thought it was good.
Thank you.
You're welcome. I've already had somebody tell me that they want to be on it.
Oh, good.
They are not on it.
Here's one.
So if we feel comfortable, we need a motion to adopt the resolution.
I move to adopt the resolution of the Gilliam County Court to establish the Gilliam County Road Committee with the format moving
As revised.
Just for clarity, it's resolution 2019-1.
Okay.
I'll second.
Okay, it's been moved and seconded to adopt resolution number 2019-01, a resolution of the Gilliam County Court to establish the Gilliam County Road Committee. Further discussion? No? All those in favor? Aye. Aye. Any opposed? Motion carries. Okay. Next one is consider facilitated goal-setting work sessions. So catch up here. I talked to a gentleman named Lindsay Hill who does some facilitated goal setting. And he actually he's worked within the county before. He worked with PCDC and the county on their very first housing public conversation that they had. He facilitated that. He's done a little bit of work, I think, with PCDC itself on some goal setting. And then I came upon him because he did some work for a former client of mine, Eastern Oregon Visitors Association, on some strategic planning. So what we talked about is basically he would do sort of phase one, some outreach and assessment before our goal setting session, where he would interview each of us individually. So when he's saying confidential in here, I think what we had talked about is him just making sure that he's not sharing your conversation with me and Leslie and vice versa, so that we're not violating public meeting law. But the idea would be he would look at any past economic development plans, any past goal setting that previous courts have done, talk to each of us. If there's some additional people within the community that we felt would be good for him to weigh in with on one-on-one interviews, he would do that. And then phase two would be a facilitated work session with us, where in essence he would come back to us and say, here's what I heard from the interviews that I said, that these were the issues that surfaced the most between all of you. And then basically over 3 to 4 hours would sort of lay out a framework for what's the goal, sort of what's the strategy, what does success look like for us. And then sort of the end product of that would be a goal and action plan, kind of a one sheet that just would guide us for this upcoming year. And then that would also be something that obviously would be accessible to the public so that they could see what we're planning on working on this year. So anyway, and he would be the primary person. He does work, it's him and his wife are partners in that, so I would envision that when I've seen them conduct these before, usually he's facilitating and she's capturing what's being said. So I would anticipate we might have the both of them working with us. It's all-inclusive, all those interviews, the travel time, and the session with us would be $2,000. So I wanted to see if you guys feel comfortable with this as a solution, if you would like me to go look at another option, or how would you like me to proceed, or us to proceed?
I think this sounds good. Look at the calendar.
It's definitely what we need.
And we had tentatively talked about, when he put some March dates in here, given that we're going to be doing our work sessions on the financial stuff up until then, I thought these were probably going to be the soonest dates. He did say that he usually puts 4 hours, but that's to allow sort of the time for people to come in, if there's bathroom breaks or things that need to happen. So the collaboration will probably be more of a 3-hour meeting, but he puts a little cushion in there in case we really get rolling. So if you guys are comfortable, I think we need a motion to accept the proposal and some direction that you want Sandy and I to go forward and schedule.
I move to accept the proposal from Hill 2 LLC to help us with our facilitated goal setting work sessions. And to have Sandy and the judge go ahead and move forward with setting those up.
I second. It's been moved and seconded that we approve the proposal from Hill 2 for a facilitated goal-setting work session, and that Sandy and I and Judge Farrar move forward with setting up the work session. Further discussion? Not all those in favor? Aye. Any opposed? Motion carries.
Judge, can I take you guys back to the road committee real quick? I don't think we really made a decision as far as advertising that and the timeline for getting interested parties in and all that sort of stuff.
I mean, I'd like to start so that Dewey's got folks on board ASAP. So if we could do that and try to maybe have people appointed by, say, maybe the first meeting in March. Is that enough time?
It would get advertised in the next week's paper, and that they would 3 weeks.
Do you think that's enough time? Have you been beating the bushes already?
I've been talking to people. I think the sooner the better. We'll have a meeting with my planning, especially with the budget coming up, you know, which direction I go and stuff. So I think 3 weeks, there's quite a bit of interest. I've had some calls and stuff, so I think we'll get.
So are we talking about leaving it open for that long, or are we gonna give them a deadline that's sooner than that?
Well, it would basically have to be in by the 27th, February 27th, so that we could have it on the agenda for the March 6th meeting.
Okay. Are we gonna advertise it once, twice, what are we
We
gonna?
can get in twice between now and then.
Okay.
And then also real quick on the road department, it's Tu's birthday.
Oh, happy birthday.
Happy birthday, Dewey.
Like Sandy.
20, are you 29 again? 29 again?
Yes.
We'll sing happy birthday to you after the meeting. I don't want it on camera.
You don't want mine to.
Okay, anything else? We're good on the road committee? Okay, let's move on to new business. 6.1, consider approval of updated Frontier Telenet Governance, IGA. So last week, the Frontier Telenet Board of Directors reviewed and approved a restatement of the IGA that created Frontier Telenet. And the real issue behind it was that originally there were 4 members. It was the 3 counties and the ESC. The ESC departed, 2 years ago now, 2.5 years ago, and neither the IGA nor the bylaws reflected that change. So that was one of the things that USAC has raised as a concern with us, is that because the ESD administers the E-rate RFPs, and then was sitting on the board that was receiving those, that there was a problem there. So this is basically just making sure that the IGA is an accurate representation of who the members actually are these days. And then the other change of note is that Commissioner McCoy in Sherman County had requested that the board members, basically the bylaws in the IGA were not consistent in that in some it said it was the judge, and then in others it said it was the member or the court appointee. And so he made the request that it be consistent and that the courts be allowed to just designate who they want as their board member and their alternate. So that's just kind of making sure that those were in order. So I reviewed it, asked quite a few questions about county liability in particular. I was concerned about what happens if Frontier Telenet takes on loans and then cannot repay them. Does that mean that the counties are on the hook for that? How does that look? The council has assured me that it in fact does not put us on the hook for Frontier Telenet's debts, that Frontier Telenet's debts are its own. So, but other than that, it seems like it's pretty straightforward.
So just to clarify on that point, so your Frontier Telenet's on it alone unless you as a body approve the transaction that Frontier Telenet has entered into. So, for example, if Frontier accepts a loan, it's Frontier's loan, but then if you as a governing body approve that by an order of you, then you do become part and parcel to them.
So give us an example of where that might come up.
Well, for example, with the Sherman County loan, Frontier accepted the loan. If the loan is brought to you as the Gilliam County Court to accept and become a part of that, then you can opt in. It's an opt-in to accept the financial obligations, not an opt-out. So you would need to take an affirmative action as your county court board in order to become obligated.
So for instance, if Frontier Telenet, I could see like, maybe not the loans with the counties, but say an agreement with Motorola. And it turns out that Frontier Telenet can't pay it, but they came to our court and said, will you, in essence, be a party to this contract and pay the Motorola bill? But then obviously if we voted, then that would obligate us to pay. But otherwise, no.
Correct.
Okay.
I had a question about the offices.
Okay.
So the principal offices are located in Morrow. What do the offices look like? I mean, what's being housed in the offices at this point?
Well, it
That's a
is.
good question.
It is an office in the, is it called the Burnett Building? Over in Morrow County. And right now, they house absolutely nothing because the files apparently have been transferred over to Wheeler County. So it used to have contracts and all that kind of stuff in. There was a discussion during the Frontier Telenet board meeting about why is the finances and the contracts in two separate locations. And so what I have heard is that since that discussion a week or so ago now, that those files have been transferred over to Wheeler County. So I'm not exactly sure why we still need an office in Morrow County.
Especially if the fiscal responsibility is made to, say, Morrow County.
Yeah. I do not believe that we're paying rent on it though, but I need to check, I would need to double check on that.
Yeah, that's a good question. Because they indicated at the meeting that there were records in like 3 different places.
Yeah.
They thought there were archived records at that Morrow location. And there were some Conan and some Fox over.
They were all over. So at least the Morrow County ones now have been moved.
To Morrow, Oregon.
The Morrow, yeah, not Morrow County. Morrow, Oregon ones have been moved to Wheeler County.
I was just wondering at this point in time, does it need to say where the principal offices are? Things being a little bit up in the air.
Well, that was where Mike was.
Right.
Yeah, originally that was where Mike was working out of. Those are really, I think most of the original IGA is still intact. The big changes were moving the NCESD out of the documents and making sure they actually reflected the real membership was the big push for why this is coming before us.
And that is, you're correct, that is the really big thing here, is that USAC has a problem with USD. They're not, they clearly withdrew, but being USAC doesn't like it.
We don't like that connection in the, so.
You don't like the connection or lack of connection?
They don't like that the ESD is the one that administers the E-rate EFP or RFP and was sitting on the board that was looking at it.
Okay.
So that has been cleared up years ago, but the paperwork does not reflect that that has been cleared up. So USAC continues to say that they're still under, they're still in our founding documents, so are they really not a member or not? And so this clarifies that, yes, indeed, they are not a member any longer.
I would move we approve the restated intergovernmental agreement with Sherman and Wheeler counties creating Frontier Telenet.
Okay, it's been moved and seconded that we approve the restated intergovernmental agreement with Sherman and Wheeler counties creating Frontier Telenet. Further discussion? All those in favor? Aye. Any opposed? Motion carries. Okay, 6.2, legal counsel update. Ruben, do Do you want me to introduce it, or would you like to share your news?
Well, I can just go right into it. I think you've all read the letter. Basically, it's been kind of a crazy year with Will Carey dying, and there's been some changes in the firm, and a couple of other attorneys have left. And so me and Mr. Van Coten, who's also on the letterhead, have decided to start our own firm and just move down the street. And so what this letter is informing you of that and asking if you would be so great as to keep me on as your attorney with the new firm. I don't anticipate any changes in the rate that I'm billing, the structure, the level of service, or anything like that. I am taking the adequate legal staff with me. It's just mainly a personal reason. I'm moving down the street and off on my own. So that's about it. And if you have any questions, I'd be happy to take those.
Wish you well. Do we need to?
So there's a question
Change
of what we want to do. So the immediate sort of question is, and this is effective March 1st, correct?
Yes, correct.
Okay. So I will just say that I do not want the county to be without legal counsel, particularly with the stuff that's going on in the Frontier Talent. I think that we need to have that resource available. I think there is a broader discussion that we maybe need to have about whether, given the transition, we want to look at putting out an RFP and just seeing, we recently did that with our auditors. So I'm kind of looking for some feedback on you guys of what you would like to do. We have sort of some options where if, for instance, if you wanted to do an RFP, we could, I think, stick with Wilkins' new firm up till, say, the $10,000 sort of threshold that we often look at before we typically go out for an RFP. And that would allow us to have counsel and then in the interim and then go through the RFP process, or it's up to you guys, kind of what, I've been looking at some feedback on how you guys would like to proceed.
We've discussed this a few times in the prior court. We discussed the RFP process for legal, especially after Will's passing. And I can't remember did we just decide not to? Did we just decide to?
Basically, yeah.
I'm trying to remember.
It was discussed and basically in the end, it was just decided to stick with Ruben and we're happy with what was working. Yeah.
Well, I guess being that I was part of that conversation, I am still of that opinion, but I will go with what the rest of the court wants to do.
Will you still be representing like Fort Arlington, or have you gone to those entities? And there's a big crossover for us on so many of our local agencies that you represent.
There is, and I have sent a similar letter to the city of Arlington and the port of Arlington. My plan is because the Frontier matters do appear to be contentious to Frontier remain with the old firm, and I've already started that transition over to another attorney at the other firm. So that did cross my mind, is that my transition, I think, will be beneficial in the coming months in dealing with the Frontier issues. And I think with the city and the port, you have a real advantage to me having my ear to the ground in Gilliam County. And I do think that from time to time, conflicts may come up. But I think that it's going to be few enough and far enough between did it, it shouldn't be an issue. If we do have to get you or another entity, outside counsel, I think that any sort of work that entails will be minor. I'm happy to set that up. Even with the previous court, I agreed to get a on-call shortlist of attorneys who can take on such things as they come up. I don't think it would be a big problem, and I think that you're going to be well served with someone who really knows what's going on.
Like we're doing with Wilkins.
Yeah, exactly. Already have an attorney lined up on that one.
That's my biggest concern.
Could you alleviate that?
And I understand, I mean, yes, you do totally have the option of going with an RFP. You have the option of just getting quotes. It's not a contract that's big enough that it requires a full-blown RFP, but if you wanted to do that, it's totally within your purview to do that. And I understand. It's up to you.
Judge,
Yeah.
would you entertain some public comment before you take action on this?
Sure.
For the record, let's rework. Move and I know each other. I'd like to take this opportunity to put on record what I would do if I were in your shoes. I would certainly continue the contract with Ruben for the short term here, given the importance of the frontier telenet situation and also some other matters that Ruben's been helpful with. But I'd also like to respectfully suggest that you do look at what you mentioned in terms of the broader picture, and either at a certain point this year or in the budget cycle this year or sometime soon, look at the broader picture of the court's use of legal counsel and how it meshes with the other entities in the county. With all due respect, I still retain the concern that I put on record prior to this having to do with Ruben or his firm serving as legal counsel for all three, actually four entities that are at the table here, quite often the fourth being Frontier Telenet. And I still share that concern, although I certainly have come to appreciate Ruben's good work and his counsel. And I'm not in any way attempting to say that because of a dissatisfaction with him, you should look at the broader picture. What I'm saying is you have a responsibility to do that overall. And so that's essentially what I would recommend. And well, I'll leave it at that. Okay, thank you.
Thank you. Does anybody else have public comment? Since we kind of opened it up. You're comfortable with it? I mean, I'm kind of, there's a piece of me that I think it may be worth looking just to open it up. I mean, I think sometimes it's a healthy process to go through. Again, not anything toward your work for us. Our elected officials in particular always say that you're very responsive to them. They're very happy with the service that they're getting, the advice that they're getting. So, but it's just sort of a broader question of, is it in the public's interest long-term to look at things like conflicts and so, yeah. But it does not sound like there's an appetite for that. Is that what I'm hearing?
Maybe not at this point.
Okay. All right. So do we then need to have a motion to employ your new firm?
Mhm.
Is that what we're looking for? Okay. Would somebody like to make the motion? Would you like me to make the motion? Let me see where you're. Matt, okay. So I would move to contract with Van Coten and Cleveland LLC for the county's legal counsel services.
I'll second.
Okay, it's been moved and seconded to contract with Van Coten and Cleveland LLC for the county's legal counsel services. Is there further discussion? Hearing none, all those in favor?
Aye.
Aye. Any opposed? Motion carries.
Thank you.
Okay. Is Brian here?
I do not see Brian. I may have forgotten.
So I think what we'll do is, before we invite OD up, I'd like to just jump ahead, just the board member reports in case OD runs. I don't know how long that discussion's gonna last, so if you don't mind, we'll put you off for just a few more minutes and then have you come back up. So, Leslie, court reports. Got anything?
Yes, not a lot, but on my first Lower John Day Area Commission on Transportation meeting was Monday, but it was canceled because of poor weather. I mean, I can't say that I was too disappointed because I didn't want to drive down the world the way things were looking that day. And other than that, I don't think there's been a lot. There was probably a question that I was probably supposed to ask in the work session, and I forgot. You know, I've been contacted lately about the internship program that we've done in the past few years, and is that part of the? I'm trying to remember. And we did not take that out of that. I don't know that that was part of the budget process, like the things we discussed this morning. It seemed to me that money came from gain share funding, which in the past is SIP money, but the county court had always felt that needed to be used for educational purposes, which the internship program kind of fell right into that. And so that's where we had taken it from. But I think Alan Cunningham was looking to me to try to tell him what his next steps are, what he needs to do, because he's already talking to, he's already trying to set up internships, and he does have the other entity that is committed $5,000, as they have in previous years. And I just really wasn't sure. I just told him I would mention it, and then we would give him some guidance on what he needed to do. I don't know how the program works.
I mean, I'm thinking, so it's been a historically, what, the last 2 years? 3 years?
Last couple of years, we had, last year, I think we went up to 4 interns. We were able to provide 4 interns. The year before, I think it was 2, possibly. It's kind of grown a little bit over the last couple of years.
So it's the first year was a 5,000 and then 5,000 from Gilliam County.
Yes.
Last year, I believe it was 5 and 15 from us. And then, so, I mean, my sense when Sandy mentioned it to me was that it should come up during the budget process itself. And then I would think that we need to just probably cycle it through the same process that the grantees are receiving funds through, would be my sense.
Okay. That's fine. Yeah, that sounds fine. Good. I just wasn't sure what to,
Yeah, it's a whole new world.
I know, I wasn't sure.
Whole new world.
Yeah, okay, that sounds good. I believe that's it for me.
Okay, Sherrie?
Well, I'm kind of like Leslie, I've been real active. I did go to, I spent some time in Condon on the 29th, and I met with Kay Lynn at the Condon Chamber of Commerce, and she outlined the projects that they're going to work on this year and their hopes and dreams. And I also had lunch with Sheriff Betancourt and got some information on Norcor, and just a learning process of how that board functions and how the jail functions, and it was very informative. And I did attend the Tri-County Court meeting, which went very quickly. We were like 30 minutes in our agenda. That was made for a really good networking time with the Sherman and Wheeler County courts. I got a chance to talk to Tom McCoy, who is the Norcor representative from Sherman County, and that was very informative as well. I'm trying to get up to speed and get some knowledge on that. And just visiting with the other commissioners. Rob Wardway, we had a sort of nice conversation as well, issues for the counties. And the Roger Tolman meeting was interesting as well. We met there. That's what I've managed. My intention
County College
is to,
next week.
yeah, we have county college next week, and my intention is to try to be in Condon 1 day a week off the regular meeting. So every week I'll be in Condon at the courthouse and let the staff members know, put together an email chain to let them know when I'm going to be there, so that if they have issues or if they've had people come to them with issues, then I'm available. Just so you all know, I am available.
Anything else?
I think that's it.
That's it. I don't even know where to start really, what to tell you. I think I've covered the stuff already, Frontier Development. I am going to be in Salem all next week. That we're not having our work session next Wednesday. So I will be talking, AOC has asked me if I would sit on their legislative committee. And so I agreed to do that because of my previous connections in the legislature. They thought that might be helpful to them. So I've agreed to do that. And then, so that will be on Monday. And then on Tuesday, I'm planning on just going up to the Capitol and start making some requests. So I've reached out to a few people in the community that might have projects that could use some state funding or support. So I'm kind of putting this out there. I'm seeing Peter in the back. That if there are additional things that you want me to take with me, to please let me know before I leave on Sunday. Because I have meetings scheduled and I'm happy to take those asks with me and just see what we can get. So, and then we'll have county college next Thursday. Very excited. So other than that, it's just whatever comes across my desk usually. So I don't have much more than that for today. All right, so it does not appear like Mr. Hunt is going to be here. So we'll just, I think, try to reschedule unless he comes in right before the end of our meeting or something. And we will move on to, go back to new business 6.4, Oregon Department of Energy presentation on the Montague Wind Project Phase 2 permitting.
I do have printed versions of the slides if you'd like to.
I would like one, please.
Yes, happy.
So, and a couple extra.
Definitely Max, our newspaper guy, so if you've got one, he definitely needs one. Thank you.
Yes, please.
All right. Now, don't fight for it, but I have one more.
You might be able to move that over a little bit, get it off the hook there, Sandy. About 2 inches over, good.
Scooched over.
But no, there's a hook on the wall there, there you go.
There you go.
I keep wanting to flop the floor.
Yeah, I thought at first it was something else.
Whenever you're ready.
Okay. Good afternoon, Judge Farrar, Commissioners Weatherall and Wilkins. My name is Chase McWay Walker. I'm a site analyst at the Oregon Department of Energy, and I'm the lead analyst on the Montague Request for Amendment 4, which is just a part of my presentation today. Thank you very much for having me here. As I mentioned, the Montague overview is just a part of my presentation. I will also be providing an overview on the siting process, like an overview of the siting process at the Oregon Department of Energy, as well as an overview on the roles and responsibilities of a special advisory group, which is what the Gilliam County Force is. So with that, I will start my presentation. Next slide, please. The Siting Division at the Oregon Department of Energy has one primary objective, and that's to review large-scale energy facilities for compliance with applicable standards and rules. We have 14 general standards, which I will discuss in the next couple slides. The Siting Division has 12 employees, and as a division, we manage the review process and lead the technical review of applications and both applications for site certificates and requests for amendments. And we make recommendations to the Energy Facility Siting Council, or EFSC. EFSC is a 7-member governor-appointed, Senate-approved group of volunteers from diverse professional backgrounds and from locations located all across the state. So not only diverse in the background, but also geographically diverse. Now, the siting process refers to the technical permitting review of a proposed energy facility against a number of predetermined standards, 14, based on site-specific locational issues that may be affected by a proposed facility. The siting process is a consolidated process as it folds in both state and local requirements. And in doing so, it eliminates duplication and varying timelines and decisions. The siting process also very much values public participation and participation from reviewing agencies, tribal governments, and special advisory groups. Lastly, the siting division also maintains responsibility for compliance of approved facilities post-certification, so retirement. We have compliance all the way up until the retirement of a facility. Compliance is always, it's ongoing, so. Okay, next slide, please. As a division, the siting division reviews applications for a variety of energy facilities. In Gilliam County, the dominant types of both proposed and approved facilities are here highlighted in red. Large wind facilities, high voltage transmission lines, and I'll get into definitions of each of these in a second, and large solar facilities. Next slide, please. Determining whether a proposed facility is state jurisdictional depends on thresholds established in statute. For wind facilities to be state jurisdictional, the peak generating capacity must exceed 105 megawatts. So there is a distinction between peak generating capacity and average generating capacity. So the peak must be above 105 megawatts. For high voltage transmission lines, to be state jurisdictional and to be considered a high voltage transmission line, the voltage must be at least 230 kilovolts or greater, so at least. It also must exceed 10 miles in length. And lastly, must also be constructed in more than one city or county in the state, so multi-jurisdictional as well. But if it checks all three of those, it's state jurisdictional. For solar arrays, a state jurisdictional facility would need to be either, it needs to either use over 100 acres of high-value farmland, use over 100 acres of arable soils, so class 1 through 4 soils, or use over 320 acres of any other type of land. That's what bumps it to state jurisdiction. Next slide, please. As mentioned, every project must meet the same 14 general standards listed here. Local government and state requirements are folded into these standards. The magnitude of what an applicant has to provide to the department in a document to document their burden of proof per standard varies on the type of energy facility and the location of the project. Because the siting process is standards-based, it's the applicant's burden of proof to demonstrate compliance with all applicable standards and rules. And if council decides, per the department's recommendation, but if the council decides that all standards are met, they must issue a site certificate. And I'd also like to note that neither council or staff can propose to relocate a proposed facility. Both council and staff must evaluate what an applicant or certificate holder has proposed. Here, highlighted in red, are two standards, land use and public services, which I just wanted to draw to your attention. These two standards are the primary standards that the Oregon Department of Energy would request Gilliam County Court as a SAG to review during the review process. That being said, any of the 14 standards, you're able to review and comment on any of the standards, but primarily we direct you to focus your attention on those two standards as they're the most applicable. Next slide, please. Here I have a flow chart of the siting process for application of the site certificate, which is different than an amendment. For an application for a site certificate, the process starts at the notice of intent. And the notice of intent is where an applicant submits, an applicant states their intent to submit an application to the department that includes general information about the project, so it's just a very, very rough preliminary step. It is not an application to construct a facility. But at this point in time, the department in practice seeks public comment both on the notice, seeks both public comment and agency review on the notice of intent or NOI. Following the NOI, the department issues a project order, which defines the analysis areas for various impacts and identifies applicable statutes and rules and ordinances that the applicant must address in their application. So that's ODO's responsibility. Following the project order, the applicant provides the department with a preliminary application for site certificate, or PASC. The preliminary application for site certificate describes the facility, it anticipates, or describes the facility and describes the anticipated impacts of the proposed facility and how applicants would meet EFSC standards, 14 standards. Once the department determines that that we have enough information to make findings per each of the standards, the PASC is turned into an application for site certificate. We have a completeness determination, and that's what switches it from a PASC to an ASC. Now, when the department receives the preliminary application for site certificate, we do post that to the department's website, and we do notice it, and we do seek reviewing agencies and SAG's evaluation and comments. And as soon as we determine that the PASC is complete, we renotice and re-request your review and evaluation of the application for the site certificate. Following completeness, the department will issue a draft proposed order. You may have seen it abbreviated as a DPO, that's common. Following issuance of the DPO, which is the department's document that addresses applicable issues identified by state and local agencies, and includes recommendations to grant with conditions or deny a site certificate. We post our DPO online and notice both to the public and to reviewing agencies that the DPO has been issued. In that notice, we do indicate a public comment deadline, which usually corresponds with a public hearing on the DPO, at the close of the hearing and the close of public comment. And following the public hearing, which is conducted by either the Energy Facility Siting Council or a hearing officer, a third-party hearing officer, let me backtrack. At the public hearing, which lays between these two steps, so it'd be right here, members of the public and reviewing agencies have an opportunity to testify or testify in person or submit in writing comments. And these comments are failure to comment at this point in time or raise a relevant issue prevents participation in the contested case step. So if you provide comments post the close of the public hearing, close of public comment, it's raise it or waive it essentially, where you don't raise a comment or an issue by that point in time, you're not able to participate in the contested case step. But if you do, then you would in theory be able to participate here. So only those persons that have raised a relevant issue in person or written during the public hearing are able to participate in the contested case. And the contested case is initiated, if a contested case is initiated, it is conducted and evaluated by a hearing officer. And the hearing officer is an identified third party. If there is a contested case, then council will review the hearing officer's recommended contested case order and take it into consideration and then make an ultimate decision on whether or not a final order and site certificate should be issued. If there is not a contested case, then council will review the proposed order of the department's proposed order and make a final decision on the final order and site certificate. Next slide, please. This flowchart is similar to the one you just saw, however, it's for an amendment, which is what I will be discussing for the Montague facility. And the amendment process is similar in steps to that of the application process. However, there is no notice of intent or project order, and we jump right into start of it at a preliminary request for amendment, or PRFA. And the PRFA is, for all purposes, the same as a application for site certificate, where a certificate holder, so let me backtrack, excuse me. An amendment, the amendment process is applicable to certificate holders and projects that have already been approved by council. And it's a process to modify what was previously approved. And so for an application, or for an amendment, it's the certificate holder providing the materials, whereas for an application, for site certificate, it's an applicant. Now in the PRFA, the certificate holder, this should say certificate holder, excuse me. The certificate holder identifies what modifications they would like to make to their facility, group facility, and at that point, the department seeks agency review, SAG review of the materials. And again, once the department determines that we've received enough information to make findings per each of the standards, we deem it complete, and it changes from a PRFA to an RFA, which is a request for amendment. At both of these stages, just like in the application process, the department posts the materials to the Siting Division website. And this red arrow indicates that for the Montag Amendment 4 that we're currently reviewing, this is where we are in the entire process, where we just deemed in January the request for amendment complete. And so we are currently drafting our draft proposed order, seeking reviewing agency and special advisory group review and comments. However, there's one difference from the application process. The first opportunity for the general public to comment on the proposed amendment comes after the department issues the draft proposed order, whereas in the application process, the general public is able to comment on the NOI, which comes before the application, ASC or PASC. And not to go on very much further, all of these steps are more or less the same as the application. However, I want to note that a contested case is not a guarantee, whereas it is in the application process. It's not guaranteed that there will be a contested case step. There's two general types of amendments. There's Amendment A and Amendment B. Amendment B doesn't include this contested case, nor does it include a public hearing, and I just indicated that difference by making this color darker than the rest. So this flowchart is representative of an Amendment A process. Next slide, please. Now I'd like to briefly go over the role and responsibilities of a special advisory group. So what is a special advisory group? A special advisory group is the governing body of a local government within whose jurisdiction a facility is proposed to be located in or is located in. And this is in statute. Statute states that council shall designate a special advisory group for new projects. Amendments to projects don't require this appointment by council, as that project has already been appointed a special advisory group. Now, the roles and responsibilities of a SAG include but are not limited to these 3 bullet points. Submitting a list of all applicable substantive criteria from the local comprehensive plan, zoning ordinances, and land use regulations that would be required if Gilliam County itself were conducting the review. Second, the department would seek SAG to submit local interpretations that county court has made regarding the criteria up here. And lastly, the department would request that the SAG submit comments regarding compliance with applicable substantive criteria and any deficiencies within the amendment or application. Next slide, please. Lastly, I wanted to point out that costs associated with the ODO review process, consultation, comments, or meeting attendance at a EFSC meeting may be eligible for reimbursement, and I made sure that we already checked to make sure that we already had an interagency or intergovernmental agreement in place with you guys, Gilliam County Court, as a SAG. So there already is one in place for this reimbursement of the review. Next slide. The next 2 slides are just a couple screen grabs of the Oregon Department of Energy Siting Division's website page. This is the home page, and there's a couple cool little tools on this page. Here on the right-hand side of the Siting Division page is an interactive GIS mapping tool, which displays all of the approved facilities in the state, be it nuclear, transmission line, any of the facilities I listed earlier, wind farms, solar farms, they all are geographically mapped. There's also some of the proposed facilities are mapped on this mapping tool as well. It's pretty self-explanatory when you click on the link how to maneuver. Underneath this tool, right here, we have a large table that lists each of the facilities and their status, whether it's being proposed or has been approved, and what type of facility, as well as the capacity, proposed capacity or approved capacity, and the county that the facility is located in. And to access a project page for facility, you would just click on the facility name itself. And so if I were to click on this top one, next slide please, it would bring me to the project page for a particular facility. Here I screen grab the Montague Wind Power Facility project page, and there's a site description, a status update as to where we are in our process, and then any applicable information to assist in your review would be found under this timeline section. Here it says project amendments, and you would just click on these hyperlinked links, and it would be taken to the data that we're asking you to review. Next slide, please. Now I would like to discuss or introduce the third part of my presentation, overview of the Montague Wind Power Facility and the request for Amendment 4. The Montague Wind Power Facility is an approved wind facility encompassing approximately 33,717 acres here in Gilliam County. And just for reference, it is just south of Arlington, which I'm circling, but north of OLEX, and the approved facility has been, is the shape that you see here highlighted in orange. And now the amendment to the facility is highlighted here in this blue green color. The Energy Facility Signing Council issued a final order on the application for the Montague Wind Power Facility in 2010. And in that final order, it approved the facility to include up to 269 wind turbines. And the wind turbines associated with the approved facility have a maximum blade tip height of 150 meters or 492 feet. The approved facility also includes a substation, approximately 10 miles of 230 kV transmission line, meteorological towers, an operations and maintenance facility, access roads, temporary construction areas. One more reference point is this line right here is Highway 19, the John Day Highway. So it sits on both sides. It's approved to be placed on both sides of the John Day Highway. So just for reference. Next slide, please. Now a little bit about the procedural history associated with the Montague Wind Power Facility. As mentioned, the original facility was approved. Final order was issued in 2010, and since there's been 3 amendments to the facility. The first coming in 2013, which approved an extension to the construction commencement and completion dates by 2 years, and a transfer of the site certificate from the approved certificate holder, which was Montague Wind Power Facility LLC, to Portland General Electric. However, the transfer was not completed, and so Montague Wind Power Facility remained the site certificate holder. The second amendment was also construction commencement and completion deadline extension of another 2 years, which bumped the construction commencement from 2013 to 2017, and then construction completion bumped from 2016 to 2020. So the current construction completion for the approved Montague facility is September 14th, 2020. And the Montague facility has gone into construction. We met their construction commencement date, which was September 14th, 2017. So they're already in construction at this point. Now, in January of last year, the department received the preliminary request for Amendment 4, which is what we are actively reviewing now. Next slide, please. This request identified 3 design scenarios that the certificate holder proposes. The first is a design scenario that is to include up to 81 wind turbines. Here identified as these green dots. These wind turbines are 2.5 megawatt wind turbines with a max blade tip height of 148 meters, I believe. Also proposed in scenario A is a battery storage system located, it's hard to see, but located right here, centrally located, and grouped with the battery storage system is an O&M facility and a second substation. And from the substation, they've proposed to construct 3 miles of overhead 230 transmission line to connect the second substation to the first substation through. And from this substation, there's approximately 10.7 miles of overhead transmission line that interconnects into the slat substation up here. Next slide. This is just a general diagram of their proposed battery storage system. Now, Montag has proposed to construct a battery storage system, as mentioned, adjacent to the phase 2, or the requested second substation. And the battery storage, as proposed, would be capable of storing up to 100 megawatts of wind or solar energy generated by the facility. And the certificate holder states that they would use the battery storage system for stabilizing the wind or solar resource through dispatching of either short-term or long-term energy stored in the batteries. Also, in their request for amendment, they've stated that they're considering one of two battery options: lithium-ion batteries or flow batteries. Both options would be capable of storing up to 100 megawatts of power. And as proposed and diagrammed here, the battery components would be stored within self-contained containers. Or an alternate option would be housing the battery components in a warehouse-type storage building of similar size and scale. This is their preferred arrangement. Now, as far as the differences between lithium-ion batteries and flow batteries are concerned, lithium-ion batteries, here diagrammed up at the top, are the most common type of utility scale battery storage system, and they're a solid state rechargeable battery. And they are used primarily at the utility scale they're used for rapid short-term deployments of power when needed, whereas flow batteries, here diagrammed in the bottom corner, refer to any battery where two electrolyte solutions, one with positive ions and one with negative ions, are contained in separate tanks. Here you can see one tank and two tanks. And the migration of the electrons from one solution to the other is what creates the electricity. And flow batteries are different from lithium ion, not only in how the electricity is created, but flow batteries also have an average lifespan of 15 to 20 years, whereas lithium ion batteries, I think, have an average lifespan of 7 to 10 or 7 to 15. So the flow batteries last longer, but they aren't able to discharge electricity as quickly as lithium ion. In the next slide, I've got a zoomed in diagram of the siting of, the proposed siting of the battery storage system. Here is the phase 2 substation as proposed, and just north of it, this, I guess for reference, is Botmiller Lane, and this is Highway 19. And so just north of this intersection is where they're proposing to site the battery storage system. And then just north of that battery storage system is their O&M building with a temporary laydown area. Next slide, please. Now, for their second proposed design scenario B, they've proposed to construct up to 48 wind turbines, and these wind turbines are proposed to be greater in size than what had previously been approved. And due to their increase in turbine dimension, they would require less amount of turbines because the capacity per turbine is greater. These turbines would be 4.2 megawatt turbines with a maximum blade tip height of 182 meters, which is 597 feet tall. Also proposed in this design scenario is a battery storage system, the same as design scenario A, substation, O&M building, transmission line. The major difference between design scenario A and design scenario B are the increase in turbine height. Next slide, please. Here's a diagram, a visual representation of the modified turbine height. Here's what's a turbine that has, this is the previously approved turbine with a max turbine blade tip height of 150 meters. And this is what is being proposed in design scenario B, a turbine that's 182 meters. So it is greater in total height. Next slide, please. Lastly, this is the design scenario C, which is a design scenario that would include both wind turbines, here indicated as the green dots, and also proposes a solar array. So it would be two forms of energy generation. And represented here as this pink outline is what the site certificate holder has labeled the solar micrositing corridor, in which they propose to construct up to 640 acres of solar. This solar micrositing corridor is approximately 1,200 acres, 1,200 acres, and so the proposed total amount of solar components within this solar micrositing corridor would be about half of what, would be about half. Now, but the impacts would not exceed 640 acres. The wind turbines proposed to be constructed in this design scenario are the 2.5 megawatt wind turbines that have already been previously approved. So there's no change in the turbine height for this design scenario. And this design scenario would also include the battery storage system, the laydown area, O&M building, and the second substation with the transmission line connecting the two substations. Next slide, please. This is a detailed diagram of their proposed solar array. Here they've broken it into 4 module blocks, and this particular configuration would include up to 51 inverters and 4 transformers, and would feature collector cables that would cross over Miller Lane into the phase 2 proposed substation. Something to note is they've also proposed to construct wind turbines down the middle of this solar micrositing corridor, which isn't identified here, but it is this area. It's more or less this rectangle. Now, all of the land within the solar micrositing corridor is dryland wheat, being used as dryland wheat farming. So that's that. Now my last slide is, you can't really see very well, but it's a visual a virtual representation of what the solar array in that particular configuration would look like, paired against what the existing landscape looks like. And this representation is taken from the intersection of Baseline Road and Highway 19. This is Highway 19, and we're looking northwest from that intersection. Baseline Road swoops down here. And so in the foreground, you would see a solar array that would have a maximum height of 15 feet if the array were fully tilted, with these 2.5 megawatt, 148 meter tall turbines running down the center. The battery storage would be way back here at the top of the intersection of Botmiller and Highway 19. Slide, please. This concludes my presentation, but I'm happy to answer any questions you may have on any of the 3 topics I discussed. I'd also like to note that the department's happy to come out and provide further presentations on this particular amendment and project, or any others for that matter. Thank you.
Do you guys have a question?
No, a lot is a repeat for me, but it's always good to hear it again, and it makes it a little clearer in my mind, so thank you.
Yes, of course.
Sherrie?
Yeah, totally overwhelming.
It's a lot of information.
Very interesting.
So I had a question on the turbine height.
Sure.
There's been an issue previously with the naval flight patterns. When you talk about the agencies that you're checking in with, is the Navy one of those? Have they weighed in on the height? I mean, personally, I think we're kind of used to seeing turbines on our landscape, but I know that that's been an issue previously, their flight patterns, and so I'm just curious if they've weighed in on whether that extra 100 feet is a concern of theirs.
So, great question. The Navy as an entity in our process is not a reviewing agency, but rather a member of the public, and as such has the kind of opportunity yet to comment on the application. However, when the department issues the draft proposed order, that is at that point in time is when it would be appropriate for the Navy or any member of the public to comment. All that being said, both the Oregon Department of Aviation and the FAA have issued determinations on the increased height, and they determined that it wouldn't be impactful. So, but that will be reflected in the draft proposed order.
May I ask?
Yeah.
So right now you've got 3 options. When does that become 1?
That is a great question for the certificate holder. I'll take note of your question and give it to them.
But there's no point in this review process where they have to say this is how we're moving forward?
We are evaluating what they've provided for all 3 scenarios. So we have been evaluating each standards for compliance, each of the scenarios compliance with each of our standards.
So if they all meet your requirements, then in essence, Monte will then just make, so say one of these doesn't, that one option would automatically be kicked out if it doesn't meet your standards, obviously. But if all 3 meet your standards, then all 3 would in essence be cited, and then Monte would choose.
Yeah.
But there's really no direction from your department to be clear on which one of those 3 they need to, as long as all 3 meet your requirements. Is that?
Yeah.
Michelle, our planning director, for the record.
Thank you. Chase, just to make it clear, this amendment 4 is referring to phase 2. Right now, Montague is cited for, correct me, 404 megawatts, which includes phase 1 and phase 2, and they're constructing phase 1 right now.
Correct.
Okay.
Yes.
And phase 2 again, when's that construction deadline or start? September, was it
For phase 1?
for phase 2?
For phase 2, in practice, the department sets a construction commencement deadline of 3 years from the issuance of a final order or site certificate. So they've requested a construction completion deadline extension to 2023, which would be 3 additional years. However, they haven't indicated a construction start date, as it's my understanding that they wish to, if all goes accordingly to plan, they wish to just roll their construction crew from phase 1 into phase 2 and start as quick as possible.
So there isn't a separate construction beginning for phase 2?
They did not propose one,
Okay,
however, we will, we're discussing what an appropriate construction date would be. But that construction commencement deadline doesn't limit how quick they can start. It just limits when they have to start by.
The latest. And the deadline's for the entire project, correct? So the 2023
That
is
would be-
phases.
We're still working on conditioning what the, as of right now, the approved facilities construction completion deadline is September of 2020. And that's for phase 1. And, but as proposed in Amendment 4, there's a construction extension for phase 2 that would be extended to 2023.
And then just one more question.
Yes.
On the solar array option, does that include fencing? Your visual doesn't include fencing, it just shows the solar panels. So is there there will be fencing around this project if it's
Correct.
constructed? Okay.
Correct, and maybe it was hard to see, but I do believe they tried to represent the fencing. I think the fencing's, I think the fencing's 10 feet and fully tilted, these are 15 feet, so you just.
Okay. And that fencing is typically cyclone fence, correct?
Yes.
What we've seen in the state.
I believe so.
Okay.
They also would be fencing off the battery storage system as well,
Oh, thank you.
and their own building substation.
Thank you.
So one other question I have, because I've never been on the planning commission, so this is kind of a new one for me, but I'm curious, the sort of the footprint that they chose appears that they, shot their flat in essence, which has always been kind of some of the better farmland, is also the area that they're proposing to site the solar array. And so I'm just curious, because I'm a newbie to this, so forgive my ignorance, if everybody else in the room gets this, is how you would cite a solar project of that magnitude on land that clearly is farm use land and have a justification for that. I guess my concern is not necessarily this project, but what stops every other neighbor from saying that they want to turn what historically and traditionally has been farmland into solar arrays? And is that a concern that you guys are looking at, not just necessarily in this project by itself, but sort of the cumulative impact over time? We've traditionally been a wind county, so this would be our first solar project, but I'm curious, you could still farm around the turbines, but obviously you can't really do that with the arrays. So I'm curious, one, how they're able to site on something that's clearly farmland, and two, does the Department of Energy look at that holistically when the next project comes in on whether that's getting away from the intent of having that be zoned as farm use? question that I just asked you unwittingly, but.
The review and evaluation of the solar array is quite extensive, and because it is our jurisdiction, the siting of the solar array would require a Goal 3 exception, and so we're currently evaluating local ordinances, zoning ordinances, to make findings on the siting of this array. And a lot of your questions, I think, are vetted out through our evaluation in what will be our land use section of our DPO. And we do look at, maybe I will need to get back to you with more insights.
That's what it is. Completely, if you want to get something back to us in writing, that's fine too, because I know there's a bigger issue. I think there's some bigger things that your department's looking at in terms of cumulative impacts and things like that. But I kind of wanted to put it on our public record too, with the understanding that might be something that you need to think about, maybe put in writing. Trust me, I understand the perils of talking in a public meeting sometimes and wanting to make sure that you're characterizing things how you want to. So, if that, so not to put you on the spot, if you would prefer to submit something back to us in writing and kind of clarify that point for us, just so that I think especially Sherrie and I, Leslie may already, it may have come up previously for her, but at least for me, it's a brand new thing for us to understand how it works. So
definitely, I'd love to provide you with a response in writing.
Okay. Any other questions?
I have one.
Sure.
So does your review include a look at the nuisance aspects of these solar panels from things such as glare or whatnot on neighbors?
The department was provided a glare analysis for the solar array, and I've reached out to the Oregon Department of Transportation for to see if they had any questions, comments, concerns on glare, specifically on the roadway, I guess, because their proposed micrositing corridor sits just above the OS community. I wanted to see if there was any concerns from ODOT of glare on the Highway 19 roadway. We also take into consideration noise impacts from wind turbines, also noise associated with the solar array. We look at those impacts and also look at impacts to habitat, right? And we look at what would appropriate mitigation for those impacts be, and we make those findings in our DPO, and the public as well as reviewing agencies and SAGs are able to comment on our DPO. And we as a department, once we've received comments, if we've received comments on the DPO, we respond to those comments in the proposed order, which is then presented to council. So we present our responses to council if we receive any comments.
Thank you.
Any other questions for Chase? There's somebody in the back.
Thanks. Is Montag using any of the Vestas equipment that's already out there? Or is it another firm?
Michelle might know that too more than.
That would probably be more appropriate of a question for the certificate holder to answer. However, the turbines approved in the request for Amendment 3 were Vestas turbines. Vestas, I believe they're 136 turbines, but having, they have started to construct this facility. However, I don't know where they are in the process of construction. I know that they've erected Met towers and have started to establish temporary laydown areas, but I'm not sure what has occurred within the last few weeks or so. That would be
That's fine.
okay. Yes.
And then the only other thing was, can you remind me the date that you needed comments back from us? Or do you, I'm sure it's back in our emails, I know, but I was wondering if you remember that, or maybe.
Off the top of my
Do you
head.
remember, Michelle, off the top of your head?
I think it was in 2 weeks
I think so.
from today.
Is that right? February 20th?
That sounds right, but I have to double check.
Yeah, I can double check as well.
I think that's it. Thank you so much for coming out and spending the time. This was helpful. Now heads are spinning and so I think the question for us is, do we have an interest in submitting comments? Okay. Sherrie? And the one thing, just from talking to Michelle about the current phase that's starting up, that we may want to weigh in with Department of Energy about, and it's not about the specifics of the amendment, but more so just, there's a way for us to better communicate some of those pieces that are being approved at the state level. There's been some issues where the building codes need to sign off on things and the state's approved it, and Michelle, the documentation's not getting passed. So if you could maybe take that back with you, that there's been a few things, a batch plant in particular, where there was an issue with the building code needed to issue a permit. Gilliam County didn't have the information we needed to be able to provide that information to the building codes to, and then the certificate holder is saying, well, it's approved by the state. So there was just it's not a big deal. I think it's just, we need to maybe work out a system so that our local planner knows what's coming and can make sure that they're in compliance. Because I think there's a little bit of the comprehensiveness. I think some of your certificate holders are thinking, well, this is a blanket. So as soon as the state says, yes, I can do whatever I want, basically. But there's still some local things that on our end, we still need to be following the process. So that would be the only thing I think that's kind of come up, that if maybe you can even, I'm not sure that's even worthy of putting in a comment for this particular thing, but more as a comment back to your department heads, is that might be something that you look at, is how we coordinate a little bit more closely with the local planners. So
Sure.
So that they know what's coming. So okay, so it does not sound like we are interested in submitting further comments beyond that. Brian Hunt showed up, so we will skip that, and he may be coming to see us at a later date. I also thought perhaps that Sandy, since that is just an update, perhaps it would be appropriate for him to do that at Tri-County Court.
A lot of it was an introduction as well, so
Yeah.
catch on some other, any other time.
But, I mean,
Right, yeah.
for him, it might be time saver to just meet all three courts
Sure.
simultaneously, if that's his intent. So, any other announcements? None?
So we've canceled next week's work session, and on February 20th, 9 a.m. at the County Courthouse at Condon, we'll have the next work session to assess the grant program updates.
And that'll be the same date as the next court date. Frontier Telnet, I think I already said was the 26th over in Sherman County. Of course, the next meeting date is 2 weeks from today. So, any other business we need to address? Okay, I'll go ahead. 2:55, still within my
Still.
2 hours. I'll adjourn the meeting.